Judgment in the matter of QX against the Secretary of State for the Home Department.
This appeal, in which the court gave judgment on the 5th of August, arises out of a respondent's application for review of the Home Secretary's decisions relating to the imposition of a Temporary Exclusion Order, or TEO, under the Counter-Terrorism and Security Act of 2015. The purpose of a TEO is to protect the public in the United Kingdom from the risk of terrorism posed by the person who is subject to the order. The TEO controls the timing and manner of the person's return to the United Kingdom. It also enables the Home Secretary to impose suitable obligations on the person when they return. The respondent is a British citizen who lived in Syria between 2014 and 2018. In November 2018, the Home Secretary applied to the High Court for permission to impose a TEO, alleging that the respondent had travelled to Syria and was or had been aligned with an al-Qaeda-aligned group. The High Court granted permission, and the Home Secretary imposed a TEO. The respondent returned to the United Kingdom in January 2019 in accordance with a permit issued by the Home Secretary. On his return, he was served with the TEO and notice of obligations imposed on him. These included obligations to report at a police station every day and to attend appointments every week. The TEO expired in November 2020, and the obligations then came to an end. In March 2021, the respondent was convicted of breaching the reporting obligation because he'd failed to report at the specified police station on a number of occasions. He received a suspended sentence. In November 2019, the respondent applied to the High Court for review of the Home Secretary's decision to impose the reporting and appointments obligations. I'll call that the obligations review. He later also sought review of the Home Secretary's decision to impose the TEO and to maintain it in force. I'll call that the imposition review. A dispute then arose between the parties as to whether the respondent is entitled, by reason of the right to a fair hearing guaranteed by Article 6.1 of the European Convention on Human Rights, to disclosure of the evidence relied on by the Home Secretary in support of the Syria allegation. That's the issue the Supreme Court is asked to decide in this appeal. The High Court held that Article 6.1 applied to the obligations review, but not to the imposition review. It followed that the respondent was entitled to disclosure of any evidence relating to the Syria allegation, which was relied on by the Home Secretary in support of the decision to impose the reporting and appointments obligations, to the extent required by Article 6.1 of the Convention. However, he was not entitled to disclosure of any other evidence relating to the Syria allegation, which was relied on by the Home Secretary in the review of the decision to impose the TEO. The Court of Appeal allowed the respondent's appeal. It held that Article 6.1 applied to the imposition review as well as the obligations review, because it would be directly determinative of the respondent's civil rights. The Home Secretary appeals to the Supreme Court. The Supreme Court unanimously dismisses the Home Secretary's appeal. It holds that the right to a fair hearing guaranteed by Article 6.1 of the Convention applies to the imposition review as well as the obligations review. This means that the Home Secretary must provide the respondent with Article 6.1 compliant disclosure of the evidence relied on in support of a Syria allegation in both reviews. The right to a fair hearing guaranteed by Article 6.1 of the Convention is a key human right. It's also fundamental under our domestic law, although the appeal is not argued on that basis. Article 6.1 applies where there is a legal dispute in which a civil right or obligation is an issue that will be directly determined by the outcome of the dispute. In the present case, it's clear that there is a legal dispute, but the question whether a challenge to the imposition of a TEO concerns the determination of a civil right or obligation is more complex. The respondent argues that the imposition review will directly determine both his right of abode in the United Kingdom and his rights under Article 8 of the Convention, which guarantees respect for private and family life. However, the Supreme Court rejects his arguments based on the right of abode. It finds that that is not a civil right within the meaning of Article 6.1. On the other hand, the parties agree that the reporting and appointments obligations were sufficiently intrusive to interfere with the respondent's Article 8 rights, and that those are civil rights for the purposes of Article 6.1. Since the obligations review will determine whether the interference with the respondent's Article 8 rights was lawful, it's common ground that Article 6.1 applies to the obligations review. The respondent submits that Article 6.1 also applies to the imposition review because the Home Secretary's power to impose the obligations is conditional on the validity of the TEO. This means that if the imposition review results in the TEO being quashed, the obligations will also be quashed. In response, the Home Secretary argues that if the TEO is upheld, the obligations will be unaffected, pending the outcome of the obligations review. The imposition review is therefore only potentially decisive of the respondent's civil rights. The Supreme Court rejects the Home Secretary's argument. It holds that where there are two distinct sets of proceedings and only one of them is immediately concerned with civil rights, Article 6.1 can nevertheless apply to both sets of proceedings, provided they are sufficiently closely linked. That test is satisfied in the present case. To begin with, although the decision to impose the TEO and the decision to impose the obligations are made under different provisions of the 2015 Act, they are in reality two component parts of a single mechanism for protecting the public from the risk of terrorism posed by the person who is subject to the TEO. Similarly, although the imposition review and the obligations review are brought under different provisions of the 2015 Act, they are so closely interrelated that Article 6.1 must apply to the imposition review if the respondent is to be given a fair hearing. Otherwise, the Home Secretary would be able to defend the decision to impose the TEO, which provides the legal basis for the obligations, on the basis of evidence that would not be disclosed to the respondent and which he would not be able to dispute or explain. The Court would not thereafter be able to undertake the obligations review with a clean slate. Rather, it would be required to review the Home Secretary's decision to impose and maintain the obligations against the background of the findings that it had made in the imposition review. The respondent would not, in those circumstances, be given a fair opportunity to challenge the underlying basis for imposing the obligations. The appeal was therefore allowed. The Court will now adjourn.